How would you like to resolve your commercial dispute and get paid quickly and efficiently? We resolve commercial disputes for business owners so you can focus on the things that are really important to you. While this may sound like an oversimplification, the number of business owners who have specialist and effective dispute resolution lawyers acting for them is small. We see many business owners trying to DIY the dispute resolution. They try a number of tactics. They meet the opposing party, they call them, they email them, they don't get what they want, and they get frustrated. Frustration can lead to writing or saying things that may be unhelpful should matters progress. Business owners tend to DIY their dispute resolution because they perceive lawyers as expensive. The truth is, lawyers can be expensive. In some cases, lawyers don't bill based on value provided. In some cases, lawyers are only focused on time spent. Unfortunately, DIY business owners and ineffective or inexperienced lawyers can cause more problems than they solve. In most cases that we see, it can be more expensive not to engage an expert than it is to engage. That is not to say that business owners can't DIY to some extent. I encourage clients to get involved to reduce costs. In these cases, we clearly outline what work is appropriate for the client to complete and what is not. We discuss this upfront so all expectations are aligned. Only business owners who engage expert litigation and dispute resolution lawyers can rest easy at night knowing that their dispute will be resolved effectively and efficiently. Hi, my name is Brent Norling. I have been working with business owners for over 7 years to resolve commercial disputes. In this time, I have been involved in literally hundreds of negotiations which have led to a settlement or judicial decision being made. I have argued cases from the District Court to the High Court, the Court of Appeal, and I've successfully barred failed litigants from further appealing to the Supreme Court. I formed Norling Law in 2015 with the vision to create a specialist practice that focuses on litigation and dispute resolution. If we form the view that the dispute is out of our area of expertise, we will refer you to other experts in this area. We will do this without hesitation. We do what we do well and nothing else. While there is a place in the market for general practice law firms in the area of litigation and dispute resolution, we believe that clients are better served by expert advice and representation. For 4 years, either Norling Law or I have been recognised for our work in this area at the New Zealand Law Awards. I also author what I practice. I am an author of New Zealand's leading text on insolvency and restructuring, and have authored precedents that are available for use by other law firms in New Zealand. I have assisted clients to resolve high-value disputes ranging from up to $38 million. I have also assisted business owners in resolving low-value disputes. We work with small business owners and rich listers alike. We approach each client with the same level of care and integrity. Ultimately, our clients get results. In the next few minutes, I'm going to tell you how we resolve disputes for our clients and how you can benefit from the same. I'm also going to share with you the mistakes most business owners make when it comes to dispute resolution, the 3 things that really matter when it comes to achieving a good resolution and result, the simple, proven process to predictably resolve a dispute. These are the same strategies that we use when resolving high or low value disputes. If you or your business is engaged in or is about to have a commercial dispute, you will love what I'm about to share with you. The top 3 people that I work with are business owners who are in a commercial dispute, accountants who need expert assistance to resolve a client's problem, and other lawyers who need expert assistance to solve a client's problem. We have clients who I first encountered when we acted against them in a dispute. Ultimately, we achieved a great result for our client at the time, and we settled the matter. Later, the former opposing party engaged us to assist them in dealing with other commercial disputes. The feedback we have received is that we are aggressive but fair, an approach that these new clients wanted adopted for future disputes. As an example, Norling Law successfully prevented the receivership of several companies that this client managed. These companies borrowed funds from a financier and were repaying them over several years. At the end of the loan period, there was a dispute as to the amount owed by the companies. The financier unreasonably threatened to place the companies into receivership. The Norling Law team acted promptly and successfully obtained an injunction from the High Court stopping the financier from placing the companies into receivership. Their actions saved the positions of more than 50 employees who were employed at the time, which would have otherwise been lost. The company now employs 85 employees. At the time, we also obtained a cost award against the financier, and our client's legal costs were close to being fully recovered by the unreasonable financier. By way of another example, another of our clients was in a heated dispute with her co-director and shareholder about the way in which the company should be run. Even the fundamentals could not be agreed upon. These two business owners needed to part ways. They should not have been in business together, and it was toxic if they remained. Unfortunately, we were not able to immediately negotiate a good outcome due to the resilient nature of the co-shareholder. His position was that our client's shares were worthless and he wanted our client to leave the business by payment of a small amount. An expert that we engaged to value the shares conservatively valued the business at $800,000. While we needed to run a strategic process for almost 1 year to obtain a result, we obtained a result that was significantly more than even our own valuation, effectively a $1 million settlement, $200,000 over our own expert's assessment of value. We did this by using all the leverage that was available to us at the time. We also put immense pressure on the other party by using the court process. We advocate alternate ways to resolve disputes. Court is not always necessary. In many cases, there are more efficient ways to resolve disputes. For example, in New Zealand, liquidators routinely issue demand letters to claw back transactions made by failed companies to its suppliers. These are known as voidable transactions. Liquidators routinely use templated demand letters. The template is onerous. It is 7 pages. It sets out law, and it is daunting for business owners to read it. Liquidators do this to shake down money, and it works. But very rarely do our clients have to repay these clawback claims. Not only do we apply expert knowledge in the negotiation, we implement robust negotiation strategies which highlight the risks to the liquidators and their alleged claim. In most cases, the claims are shut down quickly and our clients can continue their business without the stress associated with this uncertainty and unplanned claim. The best thing about using Norling Law is we will only act for you if we have the experience and expertise to add value. We are very aggressive in pursuing the interests of our clients. And last, but certainly not least, we get results. Now, in the adversarial world of litigation and dispute resolution, and I am sure you know this, people fall into one of two categories. Strugglers, people who may have some wins with the battle, but struggle to develop the right strategies to win the war. And winners, people who are on track to win the war and make it look easy. Why is it that some people have great strategies and others seem to have their previous emails or comments used against them in ways that they could not have imagined? The best way I can explain this to you is with a story about how Buster Douglas dominated Mike Tyson in 1990. Going into the fight, Tyson was the undefeated and undisputed heavyweight champion of the world. He held multiple titles. He was dominant in the ring. His previous fights ended in 93 seconds by knockout. He was to face Douglas. Douglas was considered a warm-up bout for Tyson's next event against Evander Holyfield. Tyson was a 40-1 favourite. Douglas had a number of setbacks prior to the bout. His mother had passed away. The mother of his son faced a severe kidney ailment. He contracted the flu on the day before the fight. From the beginning of the fight, Douglas displayed that he was not afraid. He had a spring in his step. He wasn't cautious in letting punches fly when he saw an opportunity. He was quick, he was accurate, and he knew Tyson was dangerous if he got inside. He didn't let Tyson in the zone of danger. His strategy to keep Tyson out was to jab, tie him up, move away, or would immediately hit Tyson with a flurry of punches. He was agile. Tyson did land punches. They hurt, but Tyson was unprepared for what he was facing. Tyson sent Douglas to the canvas in the 8th round. In the 10th round, Douglas landed a combo that sent Tyson to the ground. Douglas was the new champ. Douglas had a strategy. He knew the terrain. He knew his opponent. He controlled the urgency in the situation. He kept moving forward. He attacked the problem, he attacked the opponent, he attacked the pain, and he moved in a positive direction. Tyson was not prepared for what followed. He underestimated his opponent, he underestimated the problem, and he was unable to control the outcome. After working with hundreds of businesses and being in this industry for years, we have realized that the winners have two things in place while the strugglers have only one of the two, or sometimes none. Those two things are customized but proven strategies for the specific dispute and individuals involved, and checks and balances to ensure strategy is implemented effectively and adapted as required. Imagine knowing exactly what the strategy was to win the war, what steps were needed, and when to give you the best platform for success. Imagine knowing all of the important things that you should not say so these don't get used against you. Imagine having an expert in your corner to ensure that the strategy develops and adapts, and that you will know that it is being managed effectively. Now, let's get into the detail. There are only 3 things that really matter: having a comprehensive understanding of the law, having a robust and full understanding of the facts, and intimately knowing your opposition. Do you know your rights and obligations? Have you got a winning strategy? Have you put together the A team, the team that can bring the win home? What have you done to strategically progress this matter? Are you on track in the implementation of this strategy? Again, there are only 3 things that really matter: having a comprehensive understanding of the law, having a robust and full understanding of the facts, and intimately knowing your opposition. Only this will give you the best chance at a win. Anything else is a strategy based on hope. Any strategy based on hope is not a strategy in my view. When we work with clients, we bring to the table all of these three things. When we work with business owners and other professionals, our goal is to solve a problem. We bring to the table experience and expertise to do so. We take the stress out of resolving disputes and provide expert direction. Again, the top three people that I work with are business owners who are in a commercial dispute, accountants who need expert assistance to solve a client's problem, and other lawyers who need expert assistance to solve a client's problem. So, here is how the process works. We will focus on gathering information that is relevant to the exercise of forming our view on your legal position and the best strategy to obtain a result. We will do this at a strategy consultation to help you solve your issue. We will work through what is required to execute the strategy and follow any legal process that may be required. This strategy consultation will take around 30 minutes and you'll be speaking with me personally. I will be helping you map out an exact action plan for you to follow so that you can achieve a resolution efficiently. So who do we work with? Our clients have a commercial dispute that requires resolving. Our clients understand that a bad lawyer can lose a good case. A good lawyer can lose a bad case. Just because someone is more expensive doesn't necessarily mean that they are good or bad, and the facts of the case and the evidence available will generally have more of an impact on winning or losing a legal case. Our clients want to work with an expert who has a track record of efficiently resolving commercial disputes. Knowing that we are a good fit and that we can help you resolve the dispute is crucial. We like to get all of our clients' results, and we'd like to do this as efficiently as possible. The truth is, for some people, we cannot help. If that is the case, we'll be 100% upfront with you and we'll suggest someone else who has the required expertise or maybe an alternate strategy that does not involve lawyers. The first step is to complete an application for a free legal consultation. This is important to make sure that we are the right fit and that we can help you get a result. At this legal consultation, you will get a real appraisal of your current situation, assess possible defenses, and review strategy to resolve the issues. So next, schedule a time with us. This is where we'll really start working together to figure out what you want and how to make it happen in the fastest time possible with predictability. At the end of the call, one of two things will happen. We will either be a good fit and we can assist you. If that is the case, we'll extend an invitation to work with you to obtain a result. If we are not a good fit, that's totally okay too. There are no hard feelings or obligation. Either way, you will receive a highly valuable free legal consultation and walk away with a newfound clarity of where you are right now and how to achieve the results that could be possible. It will likely be the most valuable 30 minutes you'll invest this year. So go ahead, complete your application now, and we'll see if we can help you resolve this matter. Don't let a commercial dispute drag on. The problems usually compound if you do.